All right. So, welcome everyone to a twilight edition of Estate Planning in Prime Time. My name is Dave Kubikian, and I'm one of the attorneys at the Herzog Law Firm. A little bit about the firm: we have offices in Albany and Kingston, Clifton Park, and Saratoga. But due to COVID, we pretty much just have an office in Albany these days. We are doing some document signings in other locations. And as you can imagine, that's been a little interesting because we don't want to be at a table with you. So we're doing lots of parking lot document signings, which sounds much shadier than it actually is. We go through documents with our clients over the phone, and then the next day we have them sign their documents that we provide in a sealed envelope with markings on what to do and where to do it and so on. But these are the times we're in. We're still a full service as we get, meaning we're seeing people on video, we are talking to people over the phone, we are having them sign their documents, we're creating new documents. We're at the point now where we're about 5-6 weeks into this thing where we are now signing documents for people who we spoke to on the phone. And when we actually sign their documents, it's the first time that we're actually seeing them. So it's quite interesting. But it's a relief that we're still able to do our job, because it tends to be a pretty important job in these times. We have lots of clients who want copies of their documents or want to update things, and life got a little more real for them. And we have just a ton of people who maybe don't have the estate plan they want. They don't have a relationship with our firm yet, and they kick the tires and eventually do proceed with creating some sort of plan. And the purpose of the seminar today is to talk about the different kinds of plans there are out there, basic to rather complicated when we get into long-term care planning, and then to even touch on some pretty heavy-duty long-term care issues. It's one of those things, guys, where if we understand how things could end, it makes us better at planning now. And so even though we may not have a long-term care issue right now, and God willing, we'll never have one, when we start planning and trying to figure out what is the right set of documents for us today, it's a good idea to know what could happen down the road. This seminar is called Estate Planning in Prime Time, so I'm going to take the liberty of using some TV families that I grew up with to show some basic elements of estate planning. And because there's a number of us on here right now, and I just don't know what you have in terms of estate planning documents, I don't know how sophisticated you may be, we're going to start with the basics, and I'm going to make sure everyone step by step is in line with what I'm going to be saying. And once we got the basics down, we got the planning down together, we'll get into the whole long-term care component. So let's take this for a spin. Let's see what happens. So in terms of estate planning, right, there's really complicated estates, there's really basic estates. Sometimes, believe it or not, we can have a relatively complicated estate still be something I would characterize as basic. Your basic estate plan involves a handful of documents: power of attorney, a healthcare proxy, and a last will and testament. Okay. What are these documents? Well, power of attorney, healthcare proxy, they're kind of like cousins of one another. The idea with these documents is that we're creating in people today, during our lives, we're creating an agency relationship. We're naming agents who we pick who can also do things for us. Obviously, you can make your own decisions and you can speak on your own behalf. Here, we're naming other people who may be able to do that as well. In the case of a healthcare proxy or a living will, we're naming people for healthcare decisions. Healthcare proxies, you name an agent, that agent can talk to a doctor on your behalf. That agent can answer basic questions about your treatment for you. You're going under the knife, you're going to be under general anesthesia, your healthcare proxy can answer questions, deal with a doctor, so forth. For the living will, that relationship's a little different. You're authorizing people to speak on your behalf, but they're really relaying your wishes, what you feel, how you feel, and what you see in the future when you are kind of at the end of the road. We're not comfortable with surgeries when there's a low success rate, and when we're terminal, let us go. That kind of conversation. It's very personal. Each document is custom to you, and it's really important that you express your wishes, because your wishes may not be what your spouse's wishes are for you, or what your parents' wishes are for you, what your children's wishes are for you. And it's very personal. It's important to have this kind of basic document. Power of attorney is a little less dramatic, but it's incredibly important. In fact, it's probably the most important document that we do. With powers of attorney, we're naming an agent who can act for us. This is during our life, of course, and this is for non-medical reasons. So this is for non-medical issues. So, for example, banking, real estate transactions. One day we are out of town and we need someone to take care of our affairs. We're stuck abroad because of a travel ban, for example. Perhaps we have lost our capacity over time. Maybe we develop dementia. It's really important to have people who can act for you, sign for you, transact for you when you can't yourself. And when it comes to the power of attorney, healthcare proxy, living will, the idea is that if you can't do it yourself and you don't have a document like this in place, your loved ones, your children, whoever it is that would be your agent, they're going to need to go through court to become your guardian. And in a guardianship, not only is it expensive, like tens of thousands of dollars expensive, but it also means that we are taking away your powers and giving it to somebody else. Whereas with the healthcare proxy, you still maintain your powers. With the power of attorney, you still maintain your powers. You're just giving someone else the ability to do things in addition to yourself. Oftentimes we're doing seminars in person, and I get to say, show of hands, how many people out there have a healthcare proxy power of attorney? And I say, all right, now how many of you have looked at it in the last 10 years? And hands always dwindle, as you would expect. It's important to look at your power of attorney. It's important to make sure that it's an accurate reflection of your wishes. It's important that we still like those people, or they're still willing and able to do their job. And then even more so now than ever, it's really important that your agent has the power to do some really heavy lifting. In fact, with a good power of attorney, everything else we talk about, other than a will, everything else we talk about today, your power of attorney will be able to do on your behalf. And when we get into long-term care planning and something we call crisis planning, that's incredibly important. The last piece of your basic estate plan is obviously a will. Now, what is a will? Again, in person, I say show of hands, how many people think a will is how all of your assets are going to pass when you pass away? And every now and then I'll get a trickle of hands and say, yep, that's what the will does. In fact, it's not what the will does. A last will and testament serves to show how some of your property, how certain property is going to be conveyed at your death. I say some because we all have lots of assets that actually have nothing to do with the will and will pass in a way that goes outside of the terms of the will. That's a double-edged sword. Okay, that's going to be something I'm going to champion in a couple slides. It's also something I'm going to say is just not going to cut it for you. And both statements are true, depending on your fact pattern, your age, and your family, and all these different things that we'll get into. Everybody should have a will. Every single person needs to have that basic estate plan. And the reason why every person needs to have that basic estate plan is because I don't know what's going to happen. I don't know when it's going to happen. I don't know what your life is going to be like. And this, if nothing else, can give us some guarantees. Because we could choose to use our will. We could choose to have all our assets pass through our will. And assuming that the will is valid, it was done correctly, and it's gone through something called probate, I can almost guarantee the results as to who gets your property, when they get it, how they get it. And obviously this will be really important when it comes to kids. There are really strict requirements when it comes to wills. It's no joke. Usually it's the last thing we sign in a document signing, not because it's the most important document we do. In fact, when we do trust, it's not, but it's the one that involves the most formality. With a will, you have an executor, and that executor's job is to do what you have directed, right? So if your will says, I direct money to go to this college, well, the executor's job is to make sure that happens once they've officially been named executor by the courts. Now, I mentioned that your will doesn't govern all assets you have because everyone out there has something called non-probate property. This is property that passes to people by something called operation of law. Life insurance is a great example of this because if you have life insurance, you can name a beneficiary who's going to receive that amount of money upon your death. If I had life insurance that named my wife as my beneficiary, I do. And if I had a will that I did right now that left everything to you guys, you would not get the life insurance. And I probably would be sleeping on the couch as well if my wife knew that. But the fact is that my life insurance goes to my wife because my life insurance says goes to my wife. Doesn't matter what my will says. There's other things like this as well, right? There's retirement assets that could have beneficiaries. You could even put transfer on death, TOD, or pay on death, POD, on your bank accounts, CDs, savings bonds. So you could actually avoid your will quite easily if you wanted to. That's one side of the sword, right? I'm going to say the other side in a couple slides. That doesn't mean you shouldn't have a will. Perhaps it means you shouldn't use your will, and we'll get to that in a little bit. Now, if there is no will, and there are assets that pass through your estate, things like houses, things like financial assets that did not have a beneficiary, bank accounts that you just have in your name perhaps, a second property that you share with a brother or a family member, a family camp somewhere that you have a partial interest in. It's called dying intestate. And no, the government doesn't get your money. In fact, there's a statute that says exactly where your money goes. We're going to talk a little bit about it, and we're going to talk about different fact patterns and showing basic wills. And what I, rather complicated, I still call them basic. And they're priced basic, which is most important to our clients. But there are a lot of unintended consequences if we don't have a will, because the statute is a statute. It doesn't have lots of, well, but if this person is too immature to get the money, skip them or hold it for them. Or if this person is not alive anymore, let's go to their kids, but not now, they're 5 years old. And as you'll see in these examples, a lot of unintended consequences when we don't have a will and we die intestate. So let's use some family examples, shall we? So we'll start with one of the greatest shows of all time. Maybe not something that would be on the air these days. Certainly it was a different time. We're talking, of course, about the Bunkers and All in the Family. And we have Carol O'Connor as Archie Bunker. We have Edith Bunker, his lovely wife. And they had a daughter, Gloria. And Gloria had a husband, Michael. Basic fact pattern. Now, under New York law, if you die without a will and you have a spouse and you don't have any kids, your spouse gets everything. That's what New York law says. If you die and you're a widow or widower, so you die without a spouse, but you have kids, your kids get everything. Okay, again, relatively basic. If you don't have children, you don't have a spouse, things actually go up to your parents. And we have had fact patterns where elderly parents in nursing homes are inheriting from their kids because their kids didn't have a spouse, children, or a will. So under New York law, everything goes up. But in this fact pattern, right, if Archie, who we cross out here, passes away without a will, he is survived by a wife and a daughter. Under New York law, wife, spouse would get roughly 50% of the estate, 50,000 plus 1/2 of the other assets. And daughter, children, would get the other half. Okay. Now, what's wrong with that in this fact pattern? It seems pretty basic, right? Well, let me ask you guys a question, and I know you can't answer because I muted you all. But in the seminar, normally we get some answers. And the question is, how old are Archie and Edith in the show? In that picture right there, how old do you think they are? Most of the answers I get, in fact, the answer I would have given would have been in their late 60s. In fact, based on my research, and I don't know how accurate it is, but I think it's pretty good, they're in their early 50s. Their early 50s. And certainly they don't look that way. And even more importantly, these days, early 50s is nothing. I think you all would agree, right? The lifespan, the lifestyle now compared to the late 70s, just imagine, totally different world. And early 50s means you still have decades and decades and decades of life left. And as a principal matter, I don't want Edith to have half the money. I want her to have all the money, okay? Now, sure, you may say, well, all right, what's the big deal? Gloria has the money, she'll give the money to her mom. Yeah, I hope so. I hope she gives it, right? Or maybe she'll say, Mom, whenever you need money, I'm there for you, which sounds great. But what happens if something happened to Gloria? What happens if she predeceased Mom? Where would Gloria's money go? Well, if she had a will, hopefully she's taking care of her mom. But more importantly, if she didn't have a will, she dies without kids and a spouse. Under New York law, who gets the money? Meathead. That's right. So, what do I want here? What's the lesson? Everyone should have a basic will. If they want everything to go to their spouse, say so. I give everything to my spouse. If my spouse predeceases me, well, then I give it to my kids. And under no circumstances does it go to Meathead. It's basic will. Let's get a little more complicated, but still basic. So we're talking about the TV show Growing Pains. We're talking about the Seavers, Dr. Jason Seaver, Maggie Malone. She's a TV reporter. This is a show I probably grew up the most with. In the show, they have 3 kids, Michael, Carol, Ben. Towards the end, when they run out of fact patterns, they add Chrissy to the mix for some more drama. In this example, we're saying what happens if Alan Thicke, who played Dr. Jason Seaver, passes away, the late Alan Thicke. And same idea, without a will, 50,000 plus 1/2 to his lovely wife. The other half goes to the kids. Here there's 4 kids, so they each get 1/8. 4/8 is 1/2. So what's the issue here? Well, obviously, same thing as Edith Bunker, except here Maggie's got a lot more life. She's a little younger than Edith is, but believe it or not, she's not that much younger, and that's what that trips me out. But the idea here is a little different. Those children that get money, they're children. And it's a little different for mom to access that money if she needs it. Sure, she could use the money for the kids, but it's the kids' money, right? If anything, she'll be custodian or guardian for the kids' money at that time. In fact, depending on how much they inherit, and we may need to do a smaller guardianship through the surrogates court for minors that get more than, say, $30,000 of assets or so. I don't know if it's 30 or 20. So obviously there's some more cost involved in administering Dr. Jason Seaver's estate there. There's a bigger problem than kids getting money though. And that happens when those kids turn 18. Because when they do, no more guardian, no more custodian. Mom is not a legal guardian anymore at 18 years old. Those kids are on their own. It's their money. If they want to go to Europe and spend 3 years there instead of college, that's on them. They could do it. And I say oftentimes the only thing worse than an 8-year-old with money is an 18-year-old with money. So what would a good plan look like? What would a nice basic will look like? Everything to my spouse. If my spouse predeceases me, then everything to my kids. Next paragraph. If anyone under this will is under the age of 25, 30, 27, 22, whatever you want, hold it in trust. Give it all at this age. Give it in steps. This percentage at this age, that percentage at that age, whatever you want to do. Okay, whatever your plan is. Still a little more complicated. We'll pick on Family Ties and the Keatons. So we have Stephen and Elsie. Everyone knows Family Ties. And similar issue, right? We have children of varying ages. And in fact, Alex and Mallory are adults or theoretically adults towards the end of the show. They add a little kid and Andrew towards the end, et cetera, et cetera. In my example here, we're saying something happens to mom and dad, or eventually something happens to mom and dad. Things go to the kids, quarter, 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 quarter equals 1 whole, right? There's 4 kids. Now here we're going to talk about special needs, even though that didn't exist in the show. It exists in real life with Michael J. Fox, right? He has Parkinson's, and Parkinson's doesn't mean you need long-term care, but oftentimes it will mean that. It doesn't mean that you're on public benefits or you have special needs, but oftentimes it might. And the example here isn't about Parkinson's, it's about special needs in general. I've had clients who've come in and I look at their client questionnaire and it says they have 4 kids. We're talking and they only want to leave things to 3 of them. And it's my job to ask about why we're disinheriting someone so I can make sure I have the proper notes. I ask them and the answer is, oh no, Alex. Oh, we love Alex. Alex lives with us and all's well. No, he's a little different and he's getting some public benefits. We don't want him to lose it, so we're not leaving him any money. And I think it's a funny way to show your love to disinherit someone. And there's a better answer, and it still comes with a basic will, which says something like everything to my spouse. If my spouse predeceases everything to my kids, nothing until age 25, 30, whatever. But for Alex, next paragraph, anything going to Alex shall be held as follows. And then we follow that with about 2 pages of language that creates a supplemental or special needs trust. Mallory will be the trustee, and she can use the money set aside for her brother for his best interests. It's at her discretion. She could shower him with gifts, trips, and TVs and whatever he needs in life, but because he can't get his claws on it, it won't push him off of any public benefits he's getting. It's a smarter way to do it. Still, another option is to create a trust for him today. Alex P. Keaton Trust. And that way, other relatives can also name the trust as a beneficiary, because everything we're talking about now has this shortcoming that you'll see in a couple slides. Next are the Huxtables from The Cosby Show, and I do love this show. I don't love one of its stars, but I do love this fact pattern because it's the greatest estate planning fact pattern you can think of, because we have an affluent couple, we have a doctor and an attorney. They have kids ranging from minors to adults, real adults. They have grandchildren, okay? They have adoption. You'll see down there it says that Denise and Lieutenant Martin have Olivia. Well, Denise adopted Olivia, and that's no small fact, because where there's adoption, it's as if it's a blood relative of grandma and grandpa. The important lesson here is a little involved, and let's see if we could do it. So oftentimes our kids get married and they have children, right? That's kind of the plan. And we tend to like our in-laws until we don't. And perhaps our son-in-law breaks our little girl's heart, and no good son of a gun. And so now he's an ex-spouse. They have kids together. Normally in our documents, we say everything goes to our issue when we're talking about the kids, because issue means our children, and it also means our grandchildren. In the event, for example, Sandra predeceased us, her share would go to her kids. Same thing with Denise, her share would go to Olivia. And unless you have this documentation in there, unless you have drafting in there that talks about issue, that talks about grandkids, that talks about who's going to be in charge of their money, we may have a situation where we have grandkids inheriting money when grandma and grandpa die. And the person in charge of that money, because they are just kids, is their father, the ex-son-in-law. And that is a really big deal when you think about it. So really easy planning, everything to my spouse. If she predeceases, everything to my issue. If anyone receives under the age of blank, hold it in trust. And we'd say perhaps Theo and Vanessa are going to be trustees of any such grandchildren. Something like that. So we have blood, controlling blood. It's what most people tend to do. Although, look, I'm somebody's son-in-law, so I'm pretty good. My wife is fantastic. She's somebody's daughter-in-law. So it's not like it's all bad. You do your plan, but you can adjust your plan as bad things happen, perhaps, in life. Lastly, when it comes to TV families, we'll talk about Full House for a little bit here. So the idea here is we have a single father, Danny Tanner, raising 3 little girls. His wife, Pam, has predeceased the show. And he's raising these little girls with the help of his brother-in-law, Uncle Jesse, and his good friend, Uncle Joey. And look, if you have children who are under the age of 18, if you have children who are under the age of 18, it's terribly important they have a will. I don't care if they have 2 cents to their name. A basic will can serve to name guardians for your children. In this fact pattern, we have a blood uncle and a non-blood uncle. He's just a friend they call uncle, right? Raising these kids, and if heaven forbid something happened to Danny Tanner, I'm sure he would want uncle and uncle, right, the friend, to be in the lives of the kids, perhaps even be a guardian, and his will would give a really good head start to Joey being a guardian for those little kids that he's helping to raise. So there we go, some TV shows. Hope I didn't bore you too much. Now, you did a will. Fantastic, I convinced you. Well, we got to do it right, because we got to go through something called probate if a will is the operative document we're using to convey our assets. We got to make sure we have 2 disinterested witnesses. We got to ideally make sure an attorney was supervising all of it, because there's an assumption everything was done right. I don't know if that's a good assumption or not, but that's the assumption the court makes, and we're happy for it. If your will doesn't go through probate, if it's contested, there's some something missing, some flaw in the document signing, it is possible that we will proceed as if you didn't have a will, and then we're going through kids getting money at 18, and we're going through anyone being a guardian, and we're going through all sorts of bad news. Okay. So basic estate plan, I convinced you, not that it was that difficult, right? It's a basic estate plan. Everyone's got to have it. What else? Well, I want to then shift our eyes on avoiding probate. I want to start looking at accumulating assets and investing, although you won't see a slide about that. That's just something you should do. And then, because I'm always Debbie Downer here, I want to start looking at getting older and what that means, and long-term care and what that means. And then trying to figure out a way to deal with all of it while preserving our wealth and our control. So when it comes to avoiding probate, we already talked about a way to do it, right? Avoiding using the will. Well, we could have beneficiaries on assets. We could have non-probate assets that pass to people because that's what it said, right? My life insurance goes to my wife because that's what my life insurance says. Great. Why do we even have to talk about this anymore? The problem is that when we go through these TV families, right, we talk about the kids from Full House, or we talk about the kids from Growing Pains, we're talking about rules on when they get money. There's more rules that we have in our standard documents. What if they have a gambling problem when you've passed away? What if they have a substance abuse problem? I don't know, right? Bad things happen. So I like language, I like rules, I like a smart beneficiary. I like getting things to the right people, but someone being able to say, wait a minute, that's an awful idea for that person to get $100,000 right now, right? If your mom knew, oh my goodness, right? That kind of thing. And we can avoid that. Let me give you an example. So again, I have life insurance. My wife is my beneficiary. I'll tell you right now, I got a 6-year-old daughter, I got a 1-year-old son. Question for you. Who is my beneficiary after my wife on my life insurance? Normally at a seminar that's live in person and people are not muted, someone will say my kids, the 6-year-old and the 1-year-old. And I'll say, you're crazy because they're 6 and they're 1. They say, well, wait a minute, right? You said they don't get the money until 18. Right, but they get it at 18. Well, what about a will? You have that great will. Because life insurance, the way I have it, would go outside of probate because I'm naming those kids, no rules are attached to that money. And my nightmare isn't dying and my wife predeceasing me and money going to my kids. It's that happening and money going to them when they're at 18, because that's not going to end well. So we have two options, okay? We can actually go through probate and we can go, hey, life insurance, you know what? After my wife, if she doesn't survive me, I leave it all to the estate of me, the estate of Dave Kubikian. At least that gets things to my will, where the rules are, and I could start to hold things in trust. But probate, it's a kind of a pain in the, you know what? It costs a lot of money. It costs a lot of time. We'd like to avoid that. So what other options do we have? Well, the bottom of the screen, of course, right? Revocable trusts, and this is our first foray into trusts. Okay, so in general, there are two kinds of trusts that I want you to think about. We already talked about one whole set of them called testamentary trusts. Those are trusts that are set up in your last will and testament. Testamentary, right? Makes sense. Problem with that language, right? It definitely gets the job done. The right people get the money at the right time, all that stuff. The problem with testamentary trusts are they're in your last will and testament. They literally mean nothing until we take your will and we go to court, we go through probate. So yes, the mission accomplished, but it's not very efficient. Other kinds of trusts are called living trusts or inter vivos trusts, and those take two shapes, revocable or irrevocable. I'm going to mess it up 5 times today. With revocable trusts, it's pretty straightforward, right? Now, a trust you create during your life is like a box, right? You create a box, the box has your name on it, and it's the rules that govern the box. It's who can take things out of the box, when they can take it, how they can take it. It's those details that'll dictate what kind of trust it exactly is, what kind of inter vivos trust it is. I'd say the most basic, if that's the right terminology, would be a revocable trust. There, you're creating your own box, right? You are the settler, the creator. You settled this trust. You're the creator of this trust. You'll be the trustee of the trust. The trustee is the person who's a signatory for the trust. Okay, that's you. You'll be the income beneficiary during your life. So if you put a rental property in a trust, you put stocks, you're going to get the dividends. You are the income. You yourself are the income beneficiary. And when we put things in there, it serves to really avoid probate or deal with complicated family scenarios. That's really the goal of a revocable trust. How does it avoid probate? Well, if we take your house and we deed it to your revocable trust, then your trust is the owner of your house. Yeah, you're the trustee. Yeah, you still get the star exemption. Yeah, you still live there and you pay all the bills and everything's the same. Except technically the trust is owned by, the house is owned by the trust. You don't own it, right? I mean, you have ownership of it and everything that means, but you don't own it. And if you die, we don't need to look at your will to see what happens to that house because you don't own it. The trust does. The trust says what happens when you die. So it's like a will in terms of it says who gets what, when they get it, how do they get it. But it very importantly avoids probate because you did not own that house anymore. So revocable trusts, they're great. A really good alternative, much better than going through probate. More expensive than doing a will. So it's something that you have to weigh and see, is this right? Okay. Let's go through our list here. Avoid probate, right? Accumulate assets, investing at somebody else's seminar, okay? But do that. It's a good idea. Now let's start the plan for long-term care and preserving assets. So long-term care, the vast majority of us, let's see how many people we have, about a dozen people on the seminar, which means that about 10 of us are gonna have long-term care needs. I'd probably bet the over on that, believe it or not. If we live long enough, you're gonna have long-term care needs, and more people live longer these days. Thus, long-term care is a bigger deal. When it comes to how to deal with long-term care, the questions are, what kind of care do we need? Where is the care going to take place? Who's going to provide the care? And number one, how are we going to pay for it? In terms of financing, there are three main ways. You're paying out of your pocket. You have long-term care insurance or the Medicaid program, which we're going to focus a lot on. Now, you noticed I didn't say Medicare. We do have a couple slides on it, though, because Medicare is health insurance. It's health insurance for those who are 65 and older. There are different parts to it that range from hospitalization to medication, right? And many of our clients know of fact patterns where a neighbor, a family member had an event, they went to the hospital, they then went to rehab, they then came home, and you know what? Medicare covered all of it. And it involves a nursing home. It involves rehab in that nursing home, and Medicare covered all of it. I believe it 100%. Makes sense. The reason why is because when there is a three-day inpatient stay at a hospital, you've been admitted, okay, you're not on observation status, 3 days admitted in a hospital. If you then have to go to rehab and you are on Medicare, Medicare will cover up to the first 20 days in full. That's 100%. And days 21 through 100, they'll cover up to the next 80 days at about 80%. And this is great, right? Oh my goodness, why are we even talking about this? I'm good for 100 days. I didn't say that, right? You didn't hear me say you're good for 100 days. I said up to 20 days, then up to the next 80 days. The key is obviously up to, because at any point for anyone, you may plateau in your recovery. You may no longer need Medicare, right? Health insurance is to get you better. If you go to rehab and it turns out you now have a bad hip and you're not going to get better and you need to stay in that facility, Medicare, the health insurance, is going to cut you off. And it might be in day 2, it may be day 92. And in terms of paying 80%, the 20% they don't pay amounts to about $4,500 to $5,000 a month, depending on what month we're talking about, because they don't cover about 180 bucks a day in days 21 through 100. However, if you leave here with nothing today, most important thing is an elderly relative who's on Medicare, goes to the hospital, then needs rehab. You get in there, you say, have they been admitted? and you make sure they've been admitted for 3 days because the Medicare benefits are triggered on that prerequisite, okay? So we like to say Medicare is short-term, long-term care. Hey, we'll take it, right? Whatever gets us better and pays for the nursing facility while we're getting better. That's not long-term care though. Long-term care is we ain't getting better anymore, okay? When it comes to private paying, it's expensive. It's at least $12,000 a month. Really more $14,000, $15,000 is over $450 a day in most places per day for private paying. Okay. Not going to say everyone needs a nursing home, but if you do, the average stay in a nursing home is about 30 months, 2.5 years. That's a lot of money. Okay. So the 360 to 420, something like that of money gone for the average stay in the nursing home. So something that people do, if you don't know any better, actually you private pay until you no longer have to because you qualify for Medicaid. That's everyone's default plan. The goal of this is for you to have a better plan. Next, there's long-term care insurance, and they come in different makes and models. They're wonderful if you have it and you need it. The issue that I have with it at times is that a lot of times you don't end up needing it, and just like any other insurance, look, I'm a safe driver. I don't like paying car insurance because I know I'm not going to need it most times, but if heaven forbid I did, I'm going to sure be happy I do have it. Any long-term care conversation you have needs to include at least you checking in on this to see if it's an appropriate thing for you. It doesn't take away your need to avoid probate. It doesn't take away your need to plan who gets what. It's not this or that. It's this and that. Long-term care insurance is definitely something to look into. We can't help you with that, but I know plenty of people who can if you want some information. Lastly, there's Medicaid, okay? And Medicaid, again, is the default. The default is you spend all your money until you have no more money, and then you qualify for Medicaid. And the idea of what I do is let's maybe get Medicaid without spending all our money so we can leave our kids some of our hard-earned money that we earned during our life. Medicaid is, unfortunately, it shares 6 letters with Medicare, so it really confuses people all the time. Medicaid is a government program that, or at least this part of Medicaid, that covers long-term care for the elderly. It's a means-tested program, so you don't just qualify because you turned a certain age. You qualify because you are below a certain level of resources based on Medicaid's regulations. For 2020, the amounts of resources and income you could have isn't very high. And we're just talking about a single individual and a nursing home for a moment, because there are 2 different parts of Medicaid. There is the nursing home portion of Medicaid, and then there's actually a robust home care program called Community Medicaid that we'll spend a teeny bit of time on. We do have other seminars that go into nothing but that kind of Medicaid. But the resource amount for a single individual is not high. It's $15,750. If you think that's bad, your income cap is $50 a month, excuse me. Now, obviously, we need to know what all this means. It's easy to throw out numbers and scare people, but it's important to know what resources are, and more importantly, know what they do not include. I don't know if there are a lot of sport fans out there, but the resource cap, that's like a hard cap, right? There are salary caps in different sports, and sometimes there's a hard cap. We can't spend more than this amount of money. We are at our salary cap. And resources are very much that. If you walk in, if you apply to Medicaid and you have $30,000 in your name, you don't qualify. It's that simple. They're not going to take your money. A lot of people think Medicaid takes your money. They don't. They simply will say you don't qualify, and you'll take your own money effectively by using it on your long-term care expenses. Then you'll go back to them, and eventually you'll qualify. On the income side, when we talk about $50, that's a hard cap. For the most part, it just depends on whether we have a spouse that we can move some money to. And when it comes to community Medicaid, it's very much a soft cap where we're actually able to save all of your income. Again, I'm not going to talk a lot about community Medicaid. I just want you to understand these principles in general, because people mix them up. People see this and then they think it applies to community Medicaid, or they see the community Medicaid rules and they think it applies to nursing homes. Now, it is possible that you need a nursing home and you have a spouse who does not. and they're called your community spouse, and their resource levels are a lot higher, as is their income. And there's some degree of playing we could do between the two of you. And we try to maximize both the community spouse's resources and the applicants just to keep as much money as possible. The important thing, the headline grabbers, when it comes to Medicaid and nursing homes, is that there's a 5-year look back period, and that in general, the theory behind what Medicaid does and how they do it, right? They step in your shoes and they basically say, if you could touch your money, well then they're going to disqualify you because they're going to count it against you. They could touch your money if you could touch your money. Okay. So what are resources? Because $15,750 ain't a lot, right? So resources, the rule of thumb is if you could touch it, they could touch it. So if, for example, you have a bank account in your name, or it's in your name and another name, and you have access to it, that's your money. That's your resource. If you have CDs and cash, that's obviously a resource. Savings bonds, stocks, brokerage accounts. You call someone up, say buy, 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 sell, sell, sell. That's a resource for you. Life insurance with a cash value. The cash value is a resource, counts against you. Real estate. You have rental properties, resource. You have a second home, resource. You have a primary home, maybe, right? If we have a qualified person living in the house, that includes a spouse, a child of yours who's been taking care of you for 2 years, and we've had fact patterns where it's actually the opposite, right? Mom is still taking care of son, but then mom needs a nursing home, and we're able to say, actually, you know what? He was providing some help to her too. There's exemptions for a child caretaker as well as a disabled child exemption. So maybe when it comes to real estate, but normally it's going to be a resource, and eventually it's going to be a resource. Grandpa's a widower, he lives in his house alone. That is a resource of his, and I guarantee you it's worth more than 50 grand. Retirement, finally some good news when it comes to retirement. Only your Roth IRAs are considered to be a resource. Everything else is not considered to be a resource. Your IRAs, your 401ks, your 403bs, they are considered income, and the income rules will apply. And as you saw, $50 a month ain't a lot of income either, but at least we may have some flexibility. Or you know what, if we're in a $14,000 a month nursing home and we're losing our Social Security and pension to the tune of $3,500, well, we got off pretty good because we do have that $14,000 or $15,000 a month room for only $3,500. We don't go into our resources. Lastly, jointly held assets. A lot of people will name their daughter, add their son to their bank account. That's to avoid probate, to make bill paying easy. Unless the daughter actually provided money into that account, which normally does not happen, all of it will be considered mom's resources for purposes of her Medicaid application. It's a rebuttable presumption, so if it is in fact a truly joint account, then we could actually make it half and half, or whatever the appropriate ratio is. Now, again, the headline is this 5-year look back period, because it's great to talk about what's a resource, what's not, but it's really important to understand that Medicaid looks backwards when we apply. So if I'm doing a Medicaid application for someone who is in a nursing home right now, I'm going back to 2015, and I'm going to provide 60 months of bank statements and 5 years of quarterly brokerage account statements. I'm going to look for, and they're going to look for in those financial documents, every transaction that went from mom to somebody else. You're going to want receipts, copies of checks. They're going to flag transactions over a certain amount or routine amounts that seem shady to them. And they're looking for non-exempt transfers. They're looking for things that mom gave away. They're not looking for cruises mom went on unless she took you on the cruise and paid your way. Okay, they're looking for things that she did to get rid of her assets so she qualifies for Medicaid earlier. It runs backwards from the date that we apply, and it's a rather punitive thing, because what do they do when they find out all this stuff? Well, let's say that it turns out over the last 60 months, mom gave her kids $100,000. And you say, well, that's a lot of money. Who's giving out 100 grand? First of all, you'd be surprised. And second of all, kids have issues with money, and mom wants to help out. She wants to treat everyone equally, so she gives everyone some money. Well, she heard she can give $15,000 a pop to all her kids each year. So she does that a couple years. Okay, it happens. That, by the way, doesn't protect us from Medicaid. It just protects us from any gift tax reporting requirements. So let's just say that she had $100,000 of gifting over the last 60 months. We all agree that's the number. What Medicaid will do is it'll divide it by a regional rate, which is different in different regions in New York State. And roughly in the capital region, it's about $11,000 as a regional rate. That's the denominator. So they'll take 100 grand, they'll divide it by $11,000 a month, and they'll come up with 9. 9 represents the amount of months that mom is penalized. That's not the bad part, okay? The bad part is what the penalty means and when it starts is that she's got to pay her own way. It doesn't start when she gave the kids that money. It starts today. If she's under $15,000 of resources, so she's below the Medicaid resource allowance, she is already in a nursing facility, and she's otherwise approved in her application, right? So everything else checks out. That means when she's got $15,000 in her name, she's going to pay $15,000 a month for the next 9 months. Now, 9 times $15,000 a month is $135,000. She only gifted 100 grand. The penalty is $135,000 worth of pain. Okay, so like I said, it's a very punitive penalty. So we really want to avoid it. I've had fact patterns. Okay, we have tissue boxes in each of our conference rooms, and it's just good sanitary conditions. But sometimes people think it's in case we're dealing with a family member who lost a loved one, and we're dealing with estates and things like that. The only time I've seen somebody cry and go through a tissue box, like big time, was for Medicaid. We had a daughter and her brother. They came in for mom. Mom was in a nursing home, and this is how bad stories start in my world. They said, so mom's been in a nursing home for a year. And already I knew, because a year ago, there were things I could have done that would have made, in all likelihood, that meeting not even necessary, even if she had a foot in the nursing home, as you'll see when we do some calculations here. But then we said, all right, fine. We're fine. The nursing home said we're finally down to an amount where we could apply for Medicaid. I said, all right, well, that should be pretty straightforward. And then we said, well, what happened over the last 5 years? Did mom do any gifting to you? Any big transfers? And that's when they started to go white, because they said, well, why does that matter? And we had to break it to them that Medicaid has a penalty. And as luck had it, mom had helped daughter and her husband pay their mortgage, and they'd given some money to the son, and it was within the 5 years. So we were facing a penalty for them, and it was a penalty they would need to deal with when they didn't have any money left. And well, what if they give the money back? They didn't have it to give back. Let's just put it that way. And so they felt the reality of a penalty when there's no money. And it wasn't just that they didn't talk to us a year ago, there was this penalty, because as you'll see, we could have dealt with the penalty with the other money mom happened to have. So let's do a little bit of math, okay? So we're going to talk about something called a crisis plan, and I'm going to just go up with a number here, and let's see if we can do this together. It's a lot easier when we're in person, and I apologize for doing it through Zoom. So let's say you come into my office, and remember, the point of this isn't that you need a nursing home right now. The point is, if we understand this, it makes planning a lot easier. You got to understand how bad it could be, and the methodology behind how Medicaid looks at things, to really understand the methodology of how a trust may help you, okay? So you come into the office, Dad fell, went to a hospital, now he's at rehab, and it's not looking good. Looks like he's going to be staying there going forward. Dad's got, let's call it $235,000 in his name, okay? So we know he's allowed to have $15,000, and maybe the house is worth $200,000, and he's got no $35,000, $235,000, however we cut it. He's allowed to have 15,000, so that gets us down to 220. He's got 220 more than he's allowed to have. And then we'll say, well, maybe there are some exempt transfers we can make. We could prepay funeral with an irrevocable burial contract. I got to get paid, right? Maybe between funeral and attorney's fees and a couple odds and ends, maybe we knock off another 20 grand. So we're down to 200,000 more than we're allowed to have, okay? If you do nothing, do zero, you're going to spend 14, 15 grand a month of the 200 to pay for the nursing home until you are down to zero, because we already set aside the 15,000 that we're allowed to have. That's obviously a bad plan because we go through 200 grand. In that situation, if you have the ability to talk to us or we have the ability to help you, what we're doing is something called a loan and gift plan. This is how it works. We're going to take 100, one half of the 200,000, right? We're going to take $100,000. We're going to gift it to you, you and your siblings. And you're going to say, well, wait a minute, at 7 o'clock or so, whatever time it is on the 29th of April, you told me on slide whatever that if I give $100,000, there's going to be a 9-month penalty because of something called a regional rate, et cetera, et cetera. You're right. It's going to be a 9-month penalty. The penalty doesn't run yet because I'm not otherwise eligible. I'm not below the resource allowance. I still have an extra 100. I had an extra 200. I gifted you 100. I still have the other 100. Okay? So no penalty yet. I'm not going to apply for Medicaid. I'm not going to be approved. I have 100,000 more than I'm allowed to. Plus, I got this penalty in my face. With the other $100,000, we will have mom or dad, in this, I think I picked dad. Dad's going to loan you money. He's going to give you a $100,000 loan. It's a promissory note. It's legit. It's with an interest rate. And you are promising to pay him back the 100 grand plus interest, okay, plus interest, over the next 9 months. That's the term of the note. Okay, and that's not just some amount of time I picked out of thin air, because we will have done some pretty serious calculations based on the private pay rate of the facility and your dad's income and a couple other factors. And we're going to do the math, and we're going to have a loan of 100 grand. We're going to have a gift of 100 grand, and we're going to apply to Medicaid. And Medicaid will approve the application. They will approve the application for the, but for the penalty period, right? So we're going to do a loan and gift. We had 235. We had 15 we set aside. Legal fees, burial, whatever, take away 20. Leaves us 200. We do 100 and 100. A gift, a loan. Now, when we do both those transactions, we're only hit with a single 9-month penalty. Medicaid is okay with the loan. They're okay with it because it's an arm's length transaction. Dad is a serious business person. He's getting interest even in his old age, right? It's a arm's length transaction. And remember, Medicaid steps in your dad's shoes. If your dad can touch the money, Medicaid can touch the money. And when your dad loans you the money and your obligation is to only pay him over the next 9 months, right? $10,000, $11,000 a month. Dad can't get to all his money. That means Medicaid can't hold it against him. Okay, it's like he turned it into an annuity. So how does this all work? What's the point? Well, we file the application, Medicaid approves it, subject to the 9-month penalty, and that means the next 9 months we're private paying. How do we come up with 15 grand? Well, we have $11,000 plus interest coming back from that loan. Okay, maybe it's like 12,000 bucks or so. We have dad's Social Security. We maybe have a small pension or maybe a required minimum distribution from his retirement. Month 1 in the books. Month 2, same thing. 3, 4, 5, 6, 7, 8, 9. So 9 months of that. Month 10, the penalty's over. The loan is over. Dad's got 15 grand. His burial's paid for. Legal's done with. Medicaid starts paying. What did we accomplish? Well, if our worst case was we're going through that extra 200,000, we just made it so we only went through 100,000 of it. We saved $100,000. Plus we have the 15, plus we have the prepaid funeral. So big picture, maybe we saved about $120,000 25 grand out of that 235 scenario, so a little better than half. That's a version of a crisis plan. I got dozens of these because every fact pattern matters. It matters if you have a spouse. It matters if there's a disabled child. It matters if there's a child caretaker. It matters what transactions you did in the past and why. There's lots of bells and whistles to it. The most important thing is I do not want you to be in a position where we need to prove all of this later on. Because even though my scenario there saved 100,000, it also didn't save 100,000. Plus I had to get paid, right? I prefer to make less money because you planned years and years and years ahead of time. And that gets us to the last kind of trust. We talked about revocable. We're going to talk about our Medicaid trust now, okay? With proper planning, that Medicaid trust, yeah, it could avoid probate. Yeah, it could deal with family situations, but most importantly, it could protect assets so there's as much as possible that passes to whoever and whatever is important to you. Okay. Now, a little note on the revocable trust, right? People say, well, what about the revocable trust? If Medicaid, if you could get to your money, Medicaid can. And when you do the revocable trust and you as the creator of the trust can undo it by yourself, well, that makes it everything in there a resource to Medicaid. Which brings up a really important point, because this is, maybe I should have started with this. Okay. There's a word called revocable, there's a word called irrevocable. And I want to change your definition of those words, okay? The word revocable in my world, and in the real world, I suppose, right, in the legal world, revocable means you, the creator of the thing, can undo it, can blow it up with just your signature. I'll say it again. Revocable means you can undo something with just your signature. Okay. That's important because if you could do it with just your signature, it means it's available. It doesn't help with protecting assets. That's what revocable means. Irrevocable means not revocable. Okay. And this is where sometimes people start throwing things at me. This is why I'm happy we're on Zoom and not in person. Not revocable. Well, revocable means you by yourself can do something. Irrevocable means not that. Doesn't mean you can't do something. When we set up this kind of trust, people think you can't get to your own money. You can't take it out. You can't undo it. You can't change it. You can't do anything, right? And when it comes to revoking it, undoing it, they think, oh, what if I put money in there for something that may never happen? It's gone, and I don't want to lose control. Irrevocable means not revocable. Revocable means you by yourself can do something. Irrevocable means you by yourself cannot do it. Doesn't mean it can't be done. It means you plus one can do anything you need to do. You just can't do it by yourself. And that's important because Medicaid cares about the things only you can do. And if we need someone else to help out, well then we're protecting assets from Medicaid, right? They're not going to consider it as something that you can grab because you can't by yourself. Now, the Medicaid trust, and I know this doesn't go with my slides, it accomplishes three things. And this doesn't mean everyone needs it. I'm not telling you you need a Medicaid trust. I have no idea who you are or if you need it or not, okay? There's three things it accomplishes, and if the first two things are important, this is the only way to do it. Number one, it avoids probate for your assets because it's a trust that you created during your life, just like revocable. Number two, it protects your assets, but it does it here because you by yourself cannot undo this trust and take money out. We need a third party. Lastly, you can control your assets. I'm going to show you how you do that, but this is the only way to avoid probate, protect your assets while still controlling everything. Okay. So you see this little saying here, a box with 3 locks. Okay. The trust that you create during your life, it's a box. Let's say that thing was sealed pretty tight and we had 3 padlocks on it. Okay. When we say a box with 3 locks, it's got locks on it. Locks can be opened, right? A box with 3 locks suggests it can be open. We just need the right people involved. And if there are 3 locks on it, and I know this is an analogy that's slipping away from me, who has the keys to said locks? Well, in New York, you, the creator of the trust, the client, you have one of the keys to one of the locks. Your trustee has another key to the locks, and your beneficiaries of the trust, the people who get when you die in your trust, they have the third key. Why is this important? Why does this matter? Where the heck am I going? In New York, there's a statute that says, I don't care what the trust says, you guys can do whatever you want if all the interested parties agree. And in New York, the interested parties are you, the creator of the trust, the trustee, and the beneficiaries. And a Medicaid trust, even if it says you can't get to your money, even if it says it's irrevocable, we know to heck with that. We can get around it with your signature, the trustee's signature, and the beneficiary's signature, right? Your key, their key, their key. That doesn't sound like control to me. It shouldn't sound like control to you. I said control, and that's not control. It's not control because we need other people. The control part is we always control who those people are, because you always have the ability under our trusts to change your trustee or change your beneficiary. In an irrevocable Medicaid trust, you can amend your trust to change who gets what. You can amend your trust to change your trustee, and you can do those two things with just your signature whenever you feel like it. This sounds like it's complicated. It sounds like this is unnecessary. Well, losing $100,000 in my previous example is a big deal. And I'm going to deal with a little bit of annoyance. I'm going to deal with getting third parties involved. Maybe it's my kids at the right age. But I know, and they know, and I'm going to make sure they know that I could fire them like this. If they're out of town, I need their signature. I could amend the trust like this to get whoever's in the room to be the people who I need to sign so I could take my own money out. The other part of it is that we don't put everything you own into a trust. We're already not going to put your retirement plans in there because we don't need to. They don't count as a resource. They're treated as income. So, we put our house in because we're going to go through probate one day. We're going to spend a little bit of money to avoid probate. And by avoiding probate, you're essentially making the trust pay for itself. We have a number of questions I'm going to get to here because I think they're pertinent and I want to make sure I don't lose you. Okay. So we got a question from Carrie. Okay. So if we did a trust and 3 years into the 5-year look back period, something awful happens, we need a nursing home, what do we do? Carrie, that's the question, right? It's very fact specific. I'm going to give you a couple different scenarios. So let's say you're at 4 years and 10 months. You almost made it to 5 years. What do we do? Of course, we're going to say, let's pull out using these revocations I was just talking about, or the money you already have outside the trust. Let's private pay another month or two for that facility, get us to 5 years, and then boom, Medicaid. 3 years, now we got to look at the facts. How much money's in that trust? What's our worst case scenario? If we pulled everything out of the trust and we did that whole loan and gift thing, how do we end up? Are there some exemptions that would apply now that didn't apply when we created the trust? Maybe our child has been living with us and helping us out for a couple of years, right? All those different fact patterns are going to be really important because we're going to want to know which crisis route is going to save us the most amount of money. Sometimes it's based on how close we are to 5 years. Sometimes it's based on how much money's in the trust. Sometimes it's based on what our prognosis is. How long are you going to be living? The doctor said you got 3 months. Okay, we're going to private pay. So all of those things really are going to matter in terms of what the right next move is going to be. Okay. The idea of the Medicaid trust, just to kind of put a bow on it a little bit here, is that you can get to your money. You control it because you control the people who help you get to your money. You could fire those people. It's not control like right now when you can go to the bank and take your money out. It's control because it's like owning a restaurant and you have some, people working for you that have some, they're middle managers, they're the general manager of the restaurant. They work for you, your name's on the door, you control everything, you pay all the bills at the end of the day, and you can fire them, which is the most important, okay? And we do have a couple more questions. Let me take a quick look. So a lot of times people say, well, what if I transfer everything to my kids? Right? This sounds complicated. Looks like I'm going to spend a lot of money. What if I just want to transfer money to my kids? Well, did you hear what I said about control? I don't want you to ever lose control. And when you give something to somebody else, you are losing control. Even if they promise and pinky promise and say, no, mom, you're going to live with me. I've seen it. I've heard it. I've seen additions put on homes. I've seen people buy jet skis with your money. I don't like it. We have situations where kids die, where kids go through divorces and they commingled money. We have situations where they file bankruptcies. They have lawsuits that attack your money. I don't like it. I want you to have control of your own money no matter what. The reality is you may never need a nursing home. So while it's important to plan, it's not important enough to lose control over your assets. And that's why I like trusts in general. That's why I particularly like the Medicaid trust, because we're able to eat our cake, have our cake, eat it too, right? We can avoid probate and hopefully we have a healthy life. We never see the inside of a nursing home. Thank goodness we avoided probate, saved some money, and the trust was worth it, even without a lick of long-term care. Just a couple more slides here and I'll get through the rest of the questions. So there is an alternative and something that can help us out. And Carrie, another answer to your question is, how bad are you? You have long-term care, but maybe you could get home care. Maybe you can get care in a 55 plus community or in your apartment. And we could do that through the community Medicaid program. There is no look back period currently. That means that I could, well, tomorrow's the 30th of April. So unless I pulled a rabbit out of my hat and went to the office right now, I couldn't get any of you qualified for May because they look at the first day of the month to qualify for a particular month. But certainly any of you, I can get qualified in June, this June, right? Not 5 years from now, June, if you needed care at home. That's going to change coming October 1st. The New York State budget was passed, and in that budget, they are making some pretty big changes to community Medicaid, including instituting a 30-month look-back period, and that'll begin for applications filed October 1st of this year and later. So if you're out there or you have relatives that may need some care at home, you may want to jump on that. Give us a call, and we can get that going for you. Get that application before that look-back period starts. But the reason why I thought of you, Carrie, is because you said 3 years in. Well, 3 years in, if you did a trust and 3 years have gone by, we're past the 2.5-year community Medicaid look back. So maybe we're going to go through some months of you still living at home, getting services at home, bringing the nursing home to you, the assisted living to you. And maybe that could buy us some time, okay? It certainly makes 5 years less daunting when we know we can do community Medicaid. In addition to doing planning in advance, probably the most important thing that I do, in my opinion, well, I guess everything I do for the clients is important. This is the part that can save the most money, the whole crisis plan part. We're very good at our firm in taking fact patterns and finding the best way to preserve money when no planning was done in advance, or very little planning was done, or planning was done but not enough. Who knows? Okay. So we do Medicaid applications, and we have 3 very experienced paralegals. They actually all work for different counties in the area dealing with Medicaid applications. So it's essentially like a tax auditor who's doing your taxes. And we do provide those services. And that's what I mentioned when we did the math for that crisis plan. And lastly, we do have free consultations in any of our offices. These days, we're doing them by phone or video. It's actually quite comfortable. I think clients, believe it or not, like being in their own home when they're talking to you about their affairs rather than in some, conference room. We have a radio program that's on Saturday mornings, Magic 590 AM, 100.5 FM, 96.9 FM, and 1410 AM in the North Country. On Sundays, it's replayed on WBPM in the Kingston area. I do have a question here. So question is about, there's such a thing out there as gift taxes, and Kathy, I'll get to your question as well, okay? So there's such a thing as gift taxes. And gift taxes don't exist in New York State. It's more of a federal concept, and there is no tax you pay on a gift these days in practice. You may have heard that you can give $15,000 to anyone you want, as many times as you want, or as many people as you want per year, once per year, right? So you can get rid of a lot of money that way, tax-free. Sounds great. Well, Medicaid doesn't care about that, okay? That doesn't help us with a Medicaid application. You could actually give all your money to a charity right now, tax-free. Medicaid doesn't care about that because you could have used that money for your care. So two different principles, tax principles versus what Medicaid cares about, okay? Now, just so you know, between us, the way the federal gift tax works is that it's linked with your federal estate tax. And currently, you can pass away and give about $11 million of assets tax-free, estate tax-free. If you decided to give me 20,000 of your dollars as a gift, I'd say thank you. And that obviously would be 5 more than you're allowed to do in terms of what the annual gift tax exclusion is, 15 grand. So what does that mean that you gave me 5,000 bucks extra? What that would mean over the course of your life going forward is that, you know how you could die with 11 million bucks? Well, now it's going to be $10.995 million that you could die with. It reduces your lifetime amount. Sure, it could have big ramifications if we're moving a lot of money, either at our death or during our life. But in practice, there won't be any taxes that are going to be paid. And last question. So a lot of people have long-term care insurance. My parents have a long-term care insurance plan. They actually have a partnership plan as well. Okay. I'm happy they do. I think they had more options at the outset, but they have it now, and they're never going to get rid of it. It doesn't matter how many free trusts I offer them, it's not happening. But that's all right, right? That's their money, their plan, and so on. The beauty of this long-term care policy is that, and it's called a partnership plan, is that if you live through the benefits that your long-term care insurance provides you, there are caps on those benefits. If you live past it, you become resource eligible for Medicaid. So we won't have to do a trust to get you eligible for Medicaid. Okay, you're already resource eligible. Income rules will still apply, and you'll still have the issue of avoiding probate and how you want to do that. Maybe a revocable trust works, or maybe you do a Medicaid trust. There is validity to the idea of doing this kind of trust, Medicaid trust, just because you're going to avoid probate and nothing else. And then 5 years down the road, you have some options if it turns out that the long-term care insurance is a little too cost prohibitive based on whatever your budget is. So happy to talk about that a little more in private. I really thank you guys for listening. I hope I didn't go too late. I know that this is a lot, and I dumped it all on you, and I kind of rambled towards the end there. But I really appreciate you joining us. I'm happy to talk to you outside of the seminar, phone consults, in person, just answer a question for you, anything like that. And thanks so much. Take care.